Hello.
Hi.
We really
Hello.
assembled the dream team tonight. Courtney, Margie, Michelle, Gia. You should be charging extra for this.
I am. Did you not get my
Yeah.
memo on that?
Uh-oh, Candace is not gonna like that. How's everybody doing? I got rain and cloud where I'm at.
Yeah, same on and off for sure.
Overcast in my area.
Same. It's sunny and crazy windy in wine country.
Oh my. Margie, are you wet or sunny today?
I haven't been outside, to be honest. And my shades
And
are
your blind's closed.
I know my blinds are closed too, but I feel in my knees that it's gonna rain. I'm just kidding. I don't know. It looks kind of overcast here too. So
Yeah. Well, thank you, everybody. Thank our audience for joining us. We're just going to give everybody a few minutes to log on. We're a few minutes early. Too bad about Edmonton. They had a good run, right?
I know. It was I watched it with my husband last night. It was quite sad. Especially when Connor McDavid won what's the name of the trophy? The MVP award. But like the entire stadium was just booing. And I was like, it's so like unsportsmanlike. Like I get that you guys won the trophy, but like he did a great job.
I don't even think he came out, did he?
No, I didn't see it on the screen. I know I saw his parents take out their phone to video it because they knew it was coming, and they stopped because the booing was too loud. So they just looked like incredibly disappointed. So that was
Oh, that's not good.
So in Canadian, right?
Yeah. I think maybe that's
Florida, right?
It was in Florida.
Yeah. I had to leave. I couldn't take the stress of like they have to score. So I told my husband, just I can tell if they lost by how it's to bed. Overtime, right? So when you get to bed, it's like we're both quiet and like, okay, I already know they lost.
Oh.
So,
they had a good run. They had a very good run.
For sure.
I thought, it looked like Florida was choking, but good for them that they won, because if they didn't, all they talk about is losing 4 in a row, right? Their career would be defined by that. So not the great season they had, not all the awards. It'd just be you guys choked.
Yeah.
Right.
Yeah. They came back from a 3-1, right? A 3.
Yeah, they did.
3-0, right?
Yeah, good for them. Yeah.
And they had the best player. But McDavid, he wiped it a couple times. He seemed a bit off his game, right?
In the last game, yeah.
Yeah, it looks like he blew an edge on his skate or something.
It's the worst.
One guy cannot carry the team, right?
No.
Yeah. Especially at that level.
Well, hopefully the Leafs will win within my lifetime. Why do you laugh at that, Russ? Like every time I say that to someone, they laugh. I'm like,
I'm still holding out hope. Maybe one day. We keep saying one day.
Fingers crossed.
Before we die.
They'll do it.
1993, when they're playing LA and Gretzky hooked Gilmore. And they didn't call it. If the Leafs won that one, they would have played Montreal in the finals. That would have been something.
Yeah.
That would have been a game, all right.
The glory days, right?
The year I was born. So it's a great year.
1998?
93.
I was like, what a baby.
I know they were 98,
still a baby.
but not by much.
Oh, that's not okay.
We're covering all the generations tonight. You're going to get tips every generation you can imagine. So let's make it start. Welcome to Family Law Now After Hours. I've got 5 o'clock on my computer, so we're pretty close. Tonight's topic is Introduction to Family Court Procedures in Ontario. Very important subject if you're thinking of going to family court. The purpose of tonight's presentation is to provide general information only. It's not to be construed as legal advice. We've got some questions from our audience in advance. Thank you. If you want to submit your question, you can do so through the Q&A feature that we've turned on. And we will try to give you a response. And we also encourage you to contact a lawyer in your community to get tailored legal advice. Stay tuned to the end of tonight's presentation. We will have an ability to offer a 20-minute free consultation with one of our lawyers. If you stay tuned to the end, we'll give you the access code so you can book that at your leisure. But first of all, let's talk about our audience. Talk to our audience about our presentation presenters tonight. We have Courtney Derick. Welcome, Courtney. Over 2 decades of experience in family law, dedicated to guiding clients with empathy and professionalism. Graduated with honors from the Seneca College Law Clerk program. Recently earned a Bachelor of Arts in Psychology with distinction from York University. Thank you for joining us, Courtney.
Thanks for having me.
Next, we have Gia Williams, who's an associate lawyer with over a decade of solid litigation experience. She prides herself on being able to navigate challenging situations to create dynamic solutions. She is passionate about helping families create child-focused parenting plans. She has spent over 10 years as legal counsel with a child welfare agency and has practiced child law dealing with complex, highly emotional issues. She's gone to the Court of Appeal for Ontario, the Divisional Court, and the Supreme Court of Canada. That's quite the resume. I feel like I should be saluting you, like senior experienced member of our bar. We have another very experienced lawyer with us tonight. Margie is joining us with 14 years of experience in family law. Welcome, Margie. She's a collaborative family law, an accredited mediator, passionate about facilitating fair and reasonable settlements for her clients. Margie approaches law in a holistic manner and believes that as every family has a unique opportunity to provide emotionally intelligent advice, every family lawyer has an opportunity to provide emotionally intelligent advice to clients that will assist them in moving forward and living their lives better, keeping the interests of their children in mind. Thank you for joining us, Margie. Finally, we have Michelle. Thank you for joining us. She's worked exclusively as a law clerk since 2014, joined our firm in 2017, works closely with our clients, drafting documents and helping them guide their journey through the court system. She's committed to providing compassionate assistance to clients, ensuring their needs are met with precision and care throughout. My name's Russell Alexander. I'm one of the lawyers at this firm. I'm collaboratively trained. I've been doing family law for over 25 years. Hard to believe that it's gone on that long, but that's who I am. So enough chit chat. Let's get at it. Thank you, everybody. Introduction to family law in Ontario. Just give you a high level overview in terms of the way the system works in Ontario. So we have a number of statutes that govern most family law cases. We have the Children's Law Reform Act, the Family Law Act, which is provincial legislation, and we have the Divorce Act, which is federal legislation that applies to married couples. When you divorce or when you get separated, usually the process of sharing your property is what we call equalization, and that process is set out in the Family Law Act. There's certain dates that we look at that are important: date of separation, date of marriage, things of this nature. There's laws governing child support and parenting time. We have the child support guidelines. There's provincial guidelines and federal guidelines. Parenting is based on the best interests of the children. So that's usually Section 24 of the Children's Law Act, Children's Law Reform Act. The Divorce Act has similar language that mirrors that legislation. Basically, the court's going to be looking at the best interests of the child and looking at several factors to determine what parenting plans, what parenting time is going to be best suited. The old language was custody and access, and we've moved away from that. Those were fighting words, and we're talking about parenting time, contact orders. We've changed the language to be more child-focused. Also, I want to briefly mention there's alternative dispute resolution mechanisms available to you through mediation, arbitration, collaborative practice, where we focus on goals and interests, and we focus on not going to court. It's a very general overview of the introduction to family law in Ontario. The types of family cases, we get all types at our firm, but the big ones are divorce proceedings. That's commenced in the Superior Court of Justice for the province of Ontario. And you're seeing a Superior Court judge. We have provincial courts as well that deal with parenting and property issues, but not divorce, not property issues, parenting issues. We have property division. We've talked about that briefly. It's subject to the provisions of the Family Law Act, unless you're making a trust claim. And if you're common law, you may want to make a joint family venture claim for any property claims that you have, or a constructive or resulting trust claim. We have domestic contracts, so that could be a marriage contract or a contract that you enter into after you've been married. Sometimes we need to litigate those or negotiate new provisions. We have adoption proceedings. We have child protection proceedings. Depending on what stage the litigation's at, it may go into estate litigation for dependent claims and one spouse dies. And we also interact with bankruptcy courts. So sometimes one or more spouse may go bankrupt, and that could affect the property claims and creditors. And that can get quite complicated when you're in a family court and we have a bankruptcy court dealing with certain aspects of the claim and certain claims being stayed. So there's lots of different types of cases that go through the family court system. But let's start with the family court case. I'm going to start off with Courtney, and then we're going to move to Michelle. In terms of procedures, what do we need to know, Courtney?
Well, I suppose it depends kind of how you're starting. Generally speaking, it's an application. You ask for your relief in there with your affidavit if you have children involved with respect to parenting, and a financial statement depending on what kind of claims you're making, whether it's the Superior Court or the Ontario Court, child support, Section 7s, that sort of thing. That's mostly how court cases start. We'll keep it simple.
Michelle?
So when we have a client retain us who's ready to proceed with court, we have a few initial steps that we move forward with them. Obviously, when you have your application, and there's a lot of information that goes into that. So we generally have our clients complete what's called a narrative Q&A, and it kind of just gives us the history and background of their relationship. And important key factors that are going to help us support your arguments and the claims you're going to be seeking, whether it's property, divorce, support, parenting related. There's all different questions that we'll have you answer. And then as well, if you're dealing with support or property claims, we're going to have you complete a financial statement. If you have parenting claims, we're going to have you complete what's called a Form 35-1 affidavit regarding parenting decision-making responsibility, not custody and access, which is, as Russ said, what it used to be. We'll start working on those drafts. Once they're completed, we'll file them with the court, get them issued. That takes a bit of a process. Things have changed in the recent years. It used to be we'd go in person with a process server, have our materials issued over the counter, and now we submit them through what's called the Justice Services online portal, and issue them through there. So yeah, that's kind of the initial steps. Once it's issued, we have to get it personally served on the other side, which cannot be done by you yourself on your ex-spouse. It must be done through a third party. So we have a process server arrange that process and then, get the materials served.
I sometimes hear people say we have the rule of law, but we have the law of rules, right? So how many forms? I'm not going to hold you to the exact number. 3 forms, dozens of forms. How many forms involved in all these steps? In all the steps.
So in the initial steps or in the total?
I guess there's lots of forms. Every step has its own form.
But you're generally looking at, we have our 3 basic or standard is your application, your Form 35-1 for parenting, and your financial statement, which is your 3 initial documents that you're going to be filing with the court.
And then there's a reply, net family practice, confirmation, practice directions. It's a process involved in each one of these steps.
Yeah, and we are retained to be experts in those practice directions. So those change all the time. Courts are not unified, and so the rules change from court to court. So that's our job to make sure you're complying with those directions and making sure your materials are completed properly.
So on that note, we talked about rules. Now let's talk about these court processes. Margie, what do we need to understand? You know, what's the practice direction? What are the processes we want to be mindful of if we're going to family court?
Yeah, the practice directions, I think a lot of family lawyers, first of all, are pushing for it to be consistent throughout, because it's just, it's every court has a different practice direction, but I digress. So the process, the first step is, if it's not urgent, I don't know if I want to touch upon urgency, but if you know, a court application can be commenced on an urgent basis if there's, for example, an abduction, or dire financial need, anything truly urgent.
Let's flesh that out. If a regular application is commenced, it's 30 days, and then there's a response,
Right.
and it's a few months down the road.
Yeah,
But not everybody wants to wait a few months, right? Little Johnny's getting put on an airplane and being removed from the country.
Right. You
So
don't want to
now-
wait 30 days. No, you don't
Now
want
we're
to.
talking, that's what urgent means, or an emergency.
Yes, exactly. That would be done. You don't have to wait for an answer. Sometimes it could be done ex parte, meaning the other person isn't aware. But the usual course, if there is no urgency, yes, you file the application, the person files an answer. You could file a reply 10 days after they file their answer. And once that is done, usually there's the applicant or the respondent, in that case, can set a case conference with a judge. The case conference is the first meeting you have with a judge. It's kind of like, it's formal, but not really. It's formal in the sense that it's still a court appearance. You still have to go through the usual, you know, formalities of a court appearance. You shouldn't show up in sweats, for example. You should show up in a nice suit. But a judge cannot make an order at a case conference. But you have to have a case conference first before you can have a motion. And the motion is where you have the ability to persuade a judge and potentially get a temporary order. Okay. Not every case requires a motion. A motion is necessary if you need an order. For example, if parenting has become an issue that needs to be resolved, you can get an order for parenting. If there's the other side hasn't provided financial disclosure, for example, you could bring a motion for that. There's different kinds of motions. There's an in-person motion where you argue and provide submissions. There are 14B motions, which are over the counter. The difference is that a 14B motion, 14B over the counter, meaning you don't have to go to court. You could just file it with the courts. The only difference between a 14B and a regular motion is that 14B, it has to be a procedural issue on consent or uncomplicated. Okay. If with or without a motion, the next step would be a settlement conference. If you still can't settle a settlement conference, you then go to a trial management conference. Sometimes the judges schedule another settlement conference. You have several settlement conferences before you have a trial management conference. The trial management conference is a preparation for the Super Bowl, which is the trial, right? And that's where the trial management conference is where you talk about who the witnesses are, who they're going to be what they're going to be testifying about, what is your theory of the case, all the things that you have to deal with for the trial and how the trial will be proceeding. And then if you still haven't settled, you have the trial, which is, like I said, the number of days of a trial depend really on the number of issues and how complicated those issues are. So that's a quick overview of what the court process looks like. I don't know if you want me to go into even more detail.
You talked about case management. What's the concept behind case management, and why do we do it? And why can't a judge just make a decision when I go see him or her?
Well, I think that the whole premise behind the case conference is to allow the parties to really get into the mind of a judge, so the judge can basically tell you how he or she would decide your case and hopefully persuade you to settle. It's very helpful for people who take unreasonable positions. I find that if my client is not, is taking an unreasonable position, and I could tell them till I'm blue in the face until they hear it from a judge. So that's the whole purpose of a case conference. You get a first preview of what a judge would say or do or order. And that usually avoids the really, the huge expense of preparing for a motion, because I think a motion, guys, 5,000 to 10,000. Is that a fair amount for a motion? Whereas a case conference would be, less than that, because you're only preparing a brief. You're not preparing, affidavits, notice of motion, facta, any of those things. So you're saving yourself from potentially the cost of a motion by having a case conference.
And most reasonable people, when they hear a judge's recommendation, will follow that recommendation or settle some or all of the case based on that. But there's also this concept of you're going to have one judge from start to finish. Ideally, why do we do that unless there's a hearing and then it goes over to somebody else? What's this idea of case management where you always come back to see the same judge? Why do we do that?
I think that the idea behind that is that so the judge will be aware of the case and you don't have to repeat yourself to another judge. Not all courts have that, unfortunately. I think that's a good thing to have in every courthouse, but some courts don't have case management where you go to the next judge and they say something completely opposite from what the first judge said, which is like, oh my gosh.
And it empowers the other person to keep fighting, right?
Exactly.
Yeah.
You see, I was right. I was, the other judge got it wrong. But yeah, that's the whole idea, is that the judge is aware of the facts of the case, and judges do remember. They remember you when you appear, and they don't forget that easily.
And they gossip.
I think the purpose behind it was to try to create a more efficient journey for the case through the court, that if you have one judge who's managing it, it would allow it to travel smoothly through. So I think that was the intention. It doesn't always pan out that way, I guess, due to shortage of resources and things like that, but that was the intention behind it.
Yeah, make it more efficient. And they're usually offered at the unified family court. But I find with case management judges, they keep the notes from their last meeting. And if somebody's not following their recommendation, they're not producing disclosure order, then they can make some consequences for that person who's causing the system to slow down or being inefficient. So I think that's exactly right. All right, mediation, alternative dispute resolution. Margie, help our audience understand what we're talking about when we use these words.
Oh, sorry, thought I silenced myself there. Yeah, so the laws changed, refresh my memory, Russ. I think it was 2021 where the laws changed, both the Divorce Act and the Provincial Family Act, where you sort of have a duty to try to attempt to resolve your issues outside of court first, and you actually have to certify that when you're signing your application now. That's new. Relatively new. So when you're talking when the forms say, you attempted alternative dispute resolution, that, like you mentioned that in the beginning, Russ, the collaborative family practice, family law, or mediation, or mediation, arbitration, or even the old-fashioned way of having your lawyers negotiate, with each other and with you at a four-way meeting, for example. That is, in my opinion, the best way to do it. But, the courts are always the last resort. What a lot of people don't realize, so I'll go into very briefly what those are. Collaborative practice is you have two collaboratively trained lawyers. They help you in that process of trying to negotiate. You could, get other professionals, third-party neutrals to help you in that process, either with the finances, with a financial professional, or a neutral family professional. They assist you. It's a team effort. We all work together, and that I find that to be an effective way to resolve family law issues. Another way is mediation. It's a neutral third party. They sort of help you communicate, you and your spouse really talk about what issues you have to resolve. And then if you come to an agreement in principle, they put it in 2 minutes of settlement. Memorandum of understanding, which then you bring to a lawyer, and the lawyer drafts a separation agreement. And then that way you resolve all the issues outstanding from resulting from your separation. it becomes arbitration if you guys can't come to an agreement in mediation and you've agreed to the process of arbitration. The mediator may become an arbitrator, or you could choose another person to arbitrate whatever hasn't been resolved, and they make a decision. It's kind of like a private judge. They make the decision for you. Those are really your options for alternative dispute resolution. But the one thing I always tell people is, they think that it's a all or nothing, right? I commence a court application, now I can't try. No, you could always try to resolve out of court with the help of a mediator, with the collaborative process. I had a file where it was like, we were in mediation and we stopped it. I'm not mediation, litigation. And we're like, let's try collaborative. We tried collaborative and they came to a resolution, and the separation of agreement became minutes of settlement, right? And became an order. So, it's not all or nothing. Just because you've commenced a court application or your ex has commenced a court application, it doesn't mean that you guys can't settle out of court. And there's also mediation centers or mediation services available in courthouses as well, which I find very useful and helpful, especially for self-represented individuals, which we'll be talking about later on.
Yeah, a lot of high worth families go through mediation and arbitration just to keep their affairs private. So it can be more cost effective as well. You're not waiting for a court date, and it can be sometimes less expensive. Anything to add to mediation or arbitration, Gia?
Yeah, so if you look at the court system and the way it's sort of modeled, it's a way, there's opportunity to resolve issues all along the way. The case conference is an opportunity to try to narrow the issues and see if anything can be resolved then. The settlement conference is also another step to do that. So, it's designed to help to resolve issues before going to trial. With respect to ADR, alternative dispute resolution for child protection, there is a specific mediation for child protection. It's called child protection mediation. And if you are involved in the child welfare system and you have an ongoing child protection case, the society can make a referral. You can request that the society, the Children's Aid Society that you're involved with, make a referral for child protection mediation. In fact, in that sphere of litigation, ADR is something that you're required to look at. And it's not just mediation. There are different avenues of alternative dispute resolution, including family group conferencing. So, so those are things to be mindful of as well if you are involved in a child welfare matter.
Great. So let's talk about the role of lawyers in legal representation. You want to take this one over?
Sure. So it's really important, the role of a lawyer. The lawyers are key to helping clients address disputes, whether or not they are in court or if they are outside. The lawyers to provide advice and counsel on issues that a client may have that intersect with the law. And it's very important that the client do their homework and due diligence to make sure that they are retaining and hiring a lawyer within the area that has the expertise and training within the specific area of law. Similarly, the lawyer has that responsibility as well to ensure that when they take on a file, they have the ability and the competency to provide work in that area. And the lawyer is not just about giving advice, but also, being an advocate for that client. Like that's your voice, and the relationship is very important. It's key. The cornerstone to the relationship is good communication, solid, honest communication. And that's why you would know that information that you share with your lawyer is confidential. There are only very limited reasons or circumstances where that information is disclosed, but for the most part, you can like take comfort in knowing that there's confidentiality in that relationship. And in terms of the nature of how that retainer, if you do retain a lawyer, could be full retainer if you do end up being in court, or it could be a limited scope retainer. And that's important for some people to be aware of, because access to justice is an issue for some people in terms of finances. So it's a conversation that you can have with your lawyer around how that support can be provided or provided to you depending on the nature of your finances. So those are the points that I wanted to add.
Yeah, and ultimately, there's a question that came in about, you know, what if your client doesn't accept the case management judge's recommendation? Well, we're advocates. We can make arguments on either side of the case, and sometimes our client wants to take an unreasonable position, and we advocate for that, but that's not our advice, and we would document that and report to the client, this is what we think the outcome is going to be. But
Yeah.
your lawyer is going to provide this neutral, dispassionate advice and some strategy and tell you about the cost consequences and the risk going forward. So really,
Yeah.
really helpful.
And
So-
and an obligation of the lawyer is to, you know, try to persuade you from taking unreasonable positions and unreasonably wanting to litigate issues. So that is also the role of a lawyer too, to try to encourage settlement where it's reasonable to do. So if your lawyer is doing that, it's not just because they're telling you to want you to do that because they don't want to go to court or anything like that. They also have a responsibility to you to share that information too.
And you should be hearing the bad news from your lawyer first. You shouldn't be hearing the bad news for the first time you go see the judge and the judge delivers it to you. Your lawyer should be able to predict when bad news is coming and give you a warning that this case is not going to go well if you continue down that particular path. So that's another really important aspect. So self-representation in family court. Margie or Gia, who wants to start this one off? Margie?
I don't mind starting off. As lawyers, we've all dealt with self-reps. And if we're dealing with a self-rep, the first thing I want to say is that we have an obligation to treat them with honesty and not to take advantage of the fact that they're not lawyers. In fact, my rule of thumb is if I'm dealing with a self-rep, first of all, I don't speak to them on the phone or in person. It's always in writing, but I always treat them with kid gloves. Right? Like I treat them far better and with far more respect than I would. I try to treat everyone with respect, but
you would me?
Yeah, more respect than I would give other lawyers. No, I'm saying I try to give everyone respect, but you know what I'm saying? Like you sort of assist them without giving them advice. You guide them towards, hey, you know, you could speak to duty counsel. I think as lawyers, that's our obligation. To assist the self-rep, because at the end of the day, you're helping your client as well, right? You're helping your client. I've had clients say like, why are you helping them? Like, no, it's helping you. It's helping you resolve your case if I'm helping them indirectly. In terms of self-reps, a lot of self-reps might not know that they're also able to, like Gia mentioned, you know, retain a lawyer on a limited scope basis. On court documents, you continue to be you don't have a lawyer of record, you don't have a lawyer's name on the style of cause. It still says self-rep, but in the background, you could get help with, you know, preparing documents, getting advice, getting strategy, helping you prepare for court. And that, like Gia said, is access to justice. So yeah, like that's all I really have to say about self-reps. We help a lot of self-reps. And I think, again, it's part of our duty as lawyers to ensure that everyone has access to justice in some way.
Yeah, and we prepare, we do, so, you know, unbundled legal services where somebody may say, I just need to help bring my case conference brief together. And we'll help them do that. We're not going to show up for court, but you know, you could get these unbundled legal services from lawyers to help you at certain steps. But Gia, what do you have to say about all this?
Yeah, so with respect to the self-represented clients, I would say that it is very important because I think the rules of professional conduct, or at least the Law Society, has sort of provided caution around making sure that these individuals are not leaving with the impression that you are assisting them or too much or providing legal advice, and wanting to make sure that there isn't a situation of conflict that arises. And so you know, oftentimes they would look for guidance from another lawyer, and you know, it's important to be very transparent and clear about the limitations. You have a client, you are acting for that person, but you can direct them to get independent legal advice, perhaps from duty counsel, depending on the nature of like where you're at, if you're in court, or you know, there are resources I think that the Law Society provides for self-rep and also pro bono services and things like that. Limited, very limited, But there are limitations in what you can do to assist, and you have to be very mindful about blurring boundaries and leaving the client, the self-represented individual, with the impression that you can provide and assist them too much. But you do have to be very cautious that you are dealing with someone who isn't as knowledgeable as you are with navigating this system, and so managing those as well.
Yeah, Courtney, your experience with all this? You're on the front lines, right? You're receiving.
I am indeed. Yeah. I've interacted with self-represented individuals quite regularly. And I mean, you have to be very careful about what you say and how you say it, and, make it clear that we represent whomever, and, we represent their interests alone. Oftentimes I'll direct people to duty counsel at the courthouse and remind them that they can access those services in advance of their court date if they show up a bit early, even the day before. Sometimes duty counsel, if they're not overly busy, will assist. The family law information centers at the courts are also great resources. Some courts have students at law that'll help with drafting. I know that was like a pre-pandemic thing. I think they're back at this point. So depending on your courthouse, there's tons of resources there available as well if finances are an issue. And as always, depending on thresholds, call legal aid. They may be able to assist.
And some law school offers clinics as well. Michelle, your thoughts on all this?
Oh, just trying to find my mouse there. Yeah, no, I double up on what Courtney said. Like I said, I mean, yeah, we deal with self-represented individuals all the time. Yeah, it's just important we keep our communication in writing and very clear that, yeah, we can't act for them, rely on family law rules, and just kind of be very clear in any communication that we have with them. But as Courtney said, I will often direct self-represented parties to duty counsel and to the Family Law Information Center for resources and options, because often generally self-represented parties are self-represented because they don't have the funds for a lawyer. So like Margie said, just treating them with respect, and the fact that that's a everyday occurrence, and that there are still options out there to help them.
And one thing we haven't talked about is case lines. So there's a program to file your documents electronically with the court. We have another presentation just dealing with that. But let's talk about the practical side of self-representation. It's easy for us to say we want an adjournment, or we're going to cancel the court date because you didn't file your documents in time, or you haven't produced a disclosure. But that doesn't serve our clients. We're gonna lose that opportunity. We might wait 4 or 5 months for the next hearing. So oftentimes I'll tell the self-rep, send it to me, we'll get it into the system, we'll file it. Or if they don't have their disclosure, we'll say, let's proceed with the hearing and get recommendations on what we do have, because you don't want to lose that opportunity. And so, we're always mindful of delay and costs, and we've got a very busy court document. So I think as officers of the court, we have a duty to be advocates, but we also have a duty to assist if it's practical. I'm just going to tell a story here because I love to tell stories during live events. So we're going to trial. Wife fires her lawyer the day before trial, or he gets off the record because he's not going to get paid, maybe a bit of both. And part of the requirement was to file our draft orders and opening statements at trial. Trial starts in Oshawa. We pull Justice Magda, great judge. She didn't file anything. I don't even know if she had her file yet. And the judge looks at me, he goes, well, she didn't file her material. I go, that's right. And he goes, okay, well, why don't we break, and I want you to prepare her draft order, and I want you to prepare her opening statement. And I said, Your Honor, my client's paying me to represent him. I'm not here to. He goes, yeah, but you've been on this case from the beginning. You know what her arguments are. You know what relief she's seeking. And as an officer of the court, I'm requiring you to do this. So I took the morning off. I typed up her order for her, and I did her opening statement. And my client's shaking his head like, why are you doing this? And it actually served justice because we didn't lose a trial date. We were able to start. The judge had a good idea of what the issues were at that point in time from the wife's side. and was able to proceed with the trial. So we maybe get called upon to do it, but ultimately we want to, you know, assist the court in dispensing justice. And sometimes that means, you know, you're going to help self-reps or take steps just to make it efficient for the system to process the issues that are before it. Children's best interest. Wow, we can talk about a day on this one. Margie, I started with you last time, so let's start with Gia this time, and then we'll flip back to you.
Yes. So Russ, you had touched on it briefly about the children's best interest in terms of there are factors in the Children's Law Reform Act talks about it, as well as the Divorce Act. And so it is the focused or the primary legal principle with respect to child-centered disputes. That is where you have to sort of consider, and also where the judge will look at an order that you're looking for in terms of parenting time and decision-making authority, what is in the child's best interest. That is the key focus. And like I said, the Children's Law Reform Act outlines certain criteria to look at. That's Section 24, as well as the Divorce Act at Section 16. It outlines certain factors, and some of those include the child's needs, the child's age, stage of development, the strength of the relationship with each parent, the child's views where it can be ascertained. But there's also something very important that I feel a lot of people forget about, which is if the child has First Nations, Inuit, or Métis heritage, there is also another legislation that needs to be looked at that also has best interest factors that need to be considered in the assessment. And that legislation is the Act respecting First Nations, Inuit, and Métis children, youth, and families. So if you are or you have a client who has any of this heritage, you should be also looking at that, engaging that legislation in the analysis. And then with respect to child protection matters, you know, there is also a provision dealing with outlining the factors to be considered for the assessment. And that is Section 74(3) of the Child, Youth, and Family Services Act. And they are slightly different than those that are outlined in the Children's Law Reform Act and the Divorce Act. The provisions in the Children's Law Reform Act and the Divorce Act are very similar, but the child protection issues are slightly different. And so you have to be very mindful of those as well. And then if there is a relocation issue, there's additional factors to be looked at as well too in the best interest. And that, you know, that analysis includes what the impact of the relocation would have on the child. And that could be found at Section 16.92 of the Divorce Act and Section 34.4 of the Children's Law Reform Act.
Okay, thank you. Margie, you want to go next?
Sure. When you're in court, we have a lot of clients who want, you know, parents are assumed to know what's in the best interest of their children. The problem is when you're separating, sometimes the parties have different ideas as to what the best interest of the children are. And when you're in court, unfortunately, you're having a judge decide that for you. And one of the ways that that the court process is able to assist in determining the children's best interests, you could either, have requests for the appointment of an office of the children's lawyer, which is a government agency that, they will sort of speak to the children, get their views and preferences if they're of a certain age. They could also do an investigation and provide a report as to and provide recommendations as to what the parenting should look like. And that has a lot of weight for the judges. Or parties can hire a private assessor under Section 30, very expensive, and because you're paying, it's not part of the government. And the assessor would also do the same thing that the OCL would do, which is, do an assessment of the family and sort of provide recommendations as to what the parenting should look like. So that's how the best interest of the child is sometimes determined. I don't want to say determined, but those are tools that the courts have available for the parties to, at least give the court, the judge, some sort of evidence as to what what is in the children's best interests.
And voice of the child reports seem to be the flavor of the day in a lot of courts. Do you guys want to comment on that and how it relates to best interests?
Well, I'll defer to Gia since she's recently on the Office of Children's Lawyer panel. But my understanding is in the olden days, Russ, you know how the olden days, they used to have, the OCL would do a complete investigation with a social work assist. They would meet with the parents and observe them with the children, meet with the teachers and all the people involved in the children's care. There's a trend now, and one of the OCL on one of my files said, you know what, stop there. We don't do that anymore. Resources are stretched tight. So now it's more of, we're just expressing to you the views and preferences of the child, more of a voice of the child report, and not so much giving any sort of recommendations, not really so much. They engage the social work assist, get that fulsome investigation and provide a report only in the most clear, I think she said the most clear circumstances or that where it's necessary. So yeah. I'm seeing that as a trend. I leave that to you, Gia, if that's true or not on the other end.
The only thing I would add is that a voice of a child report is not as extensive in terms of an assessment as, like the assessment itself, right? So they're not assessing parenting per se, and it's really focusing on trying to ascertain the wishes of the children or the child who is the subject of the assessment, essentially. So that it's less extensive and not a full assessment, and it's less meetings that the OCL would have with the children than they would ordinarily if they were doing an assessment, Section 112 assessment.
You can arrange for them to be done privately by a qualified practitioner.
Correct.
I like it because you often get quick settlements. Once the parents, especially, there's a question in here about older children and how decision making is determined. You got 14, 15-year-old child expressing a certain view. Most parents are going to defer to that. So that child's just going to walk out the door and do whatever he or she wants anyway. So I find that when parents receive the voice of the child report, usually one person's upset because it's not what the child had been telling him or her, and then the case quickly settles. So certainly another tool in our toolbox. But before we leave best interests, Michelle or Courtney, do you want to talk about some of the parenting plans you put together when clients are going to court and how you sort of address the best interests in those parenting plans?
I'll let Michelle take this one if she wants it.
Sure.
I'm just going to defer to you. Yeah,
well, you want to be mindful of the best interests and kind of touch upon it when you're developing your plan, right?
Absolutely. So as I kind of said in the beginning, when we start your application, even from the very get-go, we get the background of the file. So we talk about like who was the primary caregiving parent in the relationship. There's generally a parent that takes on more of the caregiving role in the relationship. It can be a team effort. Sometimes it's not. So that's why we ask for the background and the narrative, because that goes to support your client's claim, or it kind of gives us a picture as to basically what's going to be the realistic outcome of the parenting plan for the children. So yeah, that's kind of where we go from there. And then we have your 35-1, which addresses your plan for contact for both parties. So how often you want the other spouse involved in the child's life, whether that's jointly or less than, depending on the best interest of that child, as well as involvement of other parties and who you have to support you in assisting you in raising that child. Because if you're going from a team effort to a single parent, you're going to need supports. So that's where we would put that information into your 35-1.
Yeah, I like to just ask some common sense questions, right? Mm-hmm. Hypothetically, dad comes in, never cared for the child, now realizes he's going to pay some support, and he wants 50% of the time. So I flesh out the details, right? And I ask the work schedule. Okay, so when you're not at work, who's going to care for the child? Mm-hmm. And try to put some common sense into it. for both parents, what are your roots in the community? What are your family connections? What are the routine? What's the stability? What's the schooling going to look like? What are grandparents and extended family? What are those roles going to look like? Of course, want to try to promote stability and routine whenever possible. And if you can kind of build that into your parenting plan, you may find some success. So let's move to financial disclosure and support calculations. We flipped the parenting to Michelle. So Courtney, I'm going to flip this one back over to you to start. Give her a break.
Sure. Financial disclosure is often the bane of family law files for judges and lawyers and law clerks alike. My job mostly is bothering clients for financial disclosure. It is the reality of the beast. If you've got property claims, unfortunately, you have huge disclosure requirements. Judges need to see this information in order to make accurate calculations and recommendations about equalization payments and spousal support and child support. I mean, whether you like to disclose it or not, it's inevitably going to come out. So when I send you a massive email asking you for a pile of things, please know it's not because I'm nosy, but it's because it's necessary. Support calculations are specifically that, support calculations. I mean, the tables are what they are based on income. So those are oftentimes used to help judges kind of get them to a decision that we want them to make and make their lives easier, quite frankly. If you've prepared all of those things in advance of your conference and you can make your judge's life a lot easier, they may be more inclined to make some recommendations that are good for you and your client. So, financial disclosure is one of those big things. And unfortunately, it results in my harassing clients pretty regularly, but please know it's for your best interests.
And what are we talking about when we say financial disclosure? Tax returns, assessments?
Yep, full tax returns, 30 odd pages a piece, not this 2-page summaries you like to send me. Pay stubs, notices of assessment. If you've got property issues, if you have bank statements and credit card statements from your date of marriage and your date of separation, and today, if those are massively different, we need all of those. We're required to disclose them pursuant to the rules. And that's the type of things that we're looking for. If you've been laid off or if you're on mat leave, records of employment, that sort of thing. If you're in receipt of social assistance or some other kind of benefit statements. If you've got expenses for the kidlets that you'd like to make a claim for, then we need to see those as well because we need to disclose them. A lot of stuff, unfortunately.
Yeah. Michelle, can you add to the disclosure part and talk about support calculations? We have child support, spousal support. They call it alimony in the US. What do we need to know?
Yeah, so what Courtney said, financial disclosure, it's required. And if you get to so generally, to start out, you file your financial statement, but then generally when you get to your case conference date, you're going to want to make sure that your financial disclosure is up to date. Rule 13 requires you to file what's called the 13A, which is a certificate of financial disclosure, certifying that you have complied with the disclosure requirements set out by the rules. So that is generally required to have that done by the case conference date. So like Courtney said, that's our job, is to chase after you and send off those lengthy lists of disclosure and go back and forth as to the importance and the requirements to comply with that. As far as the support calculations go, that's guidelined or governed by the guidelines, the spousal support guidelines, as well as the child support guidelines. We use our software to make those calculations by basically we input your income, which is your line 150 from your notice of assessment, and we add that into the form, and it will generate your support obligations. It'll also take into effect if you have shared parenting, it'll calculate set-off support. So two child support payments whose one's higher, so you're paying, basically the higher payer is just paying that amount that's higher than the other. And then also takes into effect the spousal support, which takes into account your years of marriage and income as well.
Yeah, the way, that's great. Thank you. The way I look at it, you have this pie, which is your family income.
Mm-hmm.
If you're a primary parent, you may be entitled to child support. You go to the guidelines, there's the table amount. you want to claim spousal support, there's a certain part of that pie you might be able to get, and there's different ways to calculate it, depending on the length of your relationship, the role you played during the course of marriage, your ability to become self-dependent and care for yourself. So remarriage, a whole bunch of factors that go into it. But before we move on, Gia or Margie, do you want to jump in on disclosure or support issues?
Well, the only thing I wanted to add, sorry, Gia.
Yeah, I was gonna say no. I think Courtney and Michelle did an excellent job covering those two.
Yeah, the only thing I want to add to Courtney's comment about, you know, clients always think like, why do you need this? It's like, we're asking because we need it. There's a reason why we need it. The other thing is, if you're a self-employed individual or you own a business, expect to require that we're going to require even more disclosure from you with respect to your business, and we might probably have to refer you to a chartered business evaluator. We have a lot of you know, self-employed or business owner clients who, you know, don't want to provide that sort of disclosure, but that's sometimes like, we have to know the value of your business, and sometimes your line 150 income is not necessarily your income for support purposes. The courts will go beyond the corporate veil and sort of look at things like retained earnings to see whether or not you actually have a higher income in reality available to pay support. So those are the only things I wanted to add.
Yeah, and there's lots of things to consider that we're not talking about tonight. Personal injury awards may or may come into play for property or support. Tax consequences of cash income or other assets. Capital gains. Some people, high net worth families often use capital gains and capital losses to reduce their income. Pension considerations, that's an asset that needs to be divided. It also can be something to consider when it's in pay in terms of the support claim potentially. Notional disposition costs. So you're going to keep an asset like a house, there could be costs associated when that house is sold, or there could be notional disposition costs with respect to pensions. There could be tax consequences, whether your support is paid monthly or lump sum. Lots of complicated issues you're going to want to get help with when thinking about disclosure and support. So let's do some Q&A in a moment, but let's quickly do rapid fire roundtable discussion. And thank you everybody for watching tonight. I've put Nicole's email address in the chat box. That's who you contact if you want to book the 20-minute consultation. The code to get the consultation is DARLA 2024. You need to book that by Friday. That doesn't mean your appointment's going to be by Friday, but you need to book it by Friday or before that access code expires. But let's go to our last topic and do a rapid fire, and then maybe we'll do some more Q&A. So common challenges and tips for success in the family court system. I'm just going to go from top left to right. So Courtney, I've got you up first.
Know your court. That's my number one tip. Each court is very different, and if you do it wrong, you'll get rejected every time.
And find the practice direction for that court. All right, Margie?
I would say get a lawyer, even if it's on a limited scope. I know. I'm like, really, you should get a lawyer, even if it's on a limited scope retainer basis, to give you advice because it'll make your life easier, and you could avoid all these sorts of things. That what practice direction should we follow? When should I file my materials? That will help you as well. So that's my big takeaway.
Yeah, Gia?
Yeah, so manage your expectations, and your lawyer will help you with that too, and understand that the court process is not as fast as you would like it to be. And there are rules, there's procedures, and so you may have to be patient.
You mean it's not like Hollywood? You just walk in and your first
No, does not happen.
You have your trial,
Yeah.
and you go and give your evidence.
No.
Michelle?
Yeah, I would say a common challenge to look out for is navigating the case line system, which is becoming a very prevalent, and like, I mean, it's a required thing to use when you're going to court. So like Margie said, even having a lawyer on a limited scope basis, like we have clients who have retained us on a limited scope basis, But so you have us in the back corner to help you navigate case lines, because clients will help us file their documents and want to represent themselves at the actual appearance, but don't know that they need to file their materials through case lines and that they need to have access to the case lines throughout the proceeding. So having a lawyer in your back pocket to assist you with how to navigate that part of the court system is definitely helpful.
Yeah, great tips. I would say make lists, right? When you go to court or when you go to see your lawyer, it can be overwhelming. You may forget things, especially if you're representing yourself and you're making submissions. Have a list of points that you want to make. You may shut down, you may be stressed, you may forget what you want to say. Get help. Lawyers and legal professionals like you see on the screen today provide neutral, balanced advice, fair bit of strategy and chess playing that goes on when you go to family court in terms of timings of offers to settle, what the judge wants to see in a brief and what they do not want to see. Understand the risks of proceeding. So your lawyer is going to help you with strategy, will tell you the strengths and weaknesses of your case, will help you see the unknown knowns and the consequences of the decisions that you're making, whether it's a week down the road or 20 years down the road. I can't say strong, lawyers get this wrong, and lawyers sometimes have difficulty filing documents online. To understand it as a layperson, it's super challenging. So access help, even if you're going to do it on an unbundled basis, but certainly it's worth it, especially if you're talking about, your liberty, your identity, your home, your children, your money, all these things that define people usually get changed when you go through a separation and divorce. And you want to make sure you get it right. So a couple quick rapid fire from the Q&A, and then I'm going to throw some additional questions out. So there's no slides tonight. Can you bring a motion that was not issued or discussed at a case conference? Not like relocation, not likely unless it's urgent and you can demonstrate that. Lawyer lost their license to contact the Law Society or have another lawyer help you get your file back and get it back on track. We talked about parenting time for children nearing the age of majority. What if the other parent's working for cash? Well, we have experts who can determine that, get some evidence before the court. You want to gross it up before you do any support calculations. And Darla 2024 is the code. Email Nicole@russellalexander.com if you want to book a consultation. So let's go through some questions that we also got in advance. So here's one for you, Margie. How do alternative dispute resolutions like mediation or collaborative law compare to the traditional family court system? What's your experience been?
I'm sorry, the question is how
do arbitration and collaborative practice compare to the traditional way of going to court?
Well, those out of court options, you have a bit more control, right? You have a bit more control when you're negotiating through the collaborative process, for example, or through just, collaborative with a small C lawyer, or if you're going through mediation, you have a lot of control and you could probably get a more tailor-made agreement that fits for you, that fits you, your spouse's life, your children's lives, a lot better than if you went to court, because a court, you're really, giving up your control and your decision making to a third party judge who doesn't really know you other than what you put in your documents.
In a successful collaborative case, the clients are usually much more content with the outcome. They may not like it, but it's acceptable. Gia, do you want to add to that?
Yeah, so I've looked into this before, I did some research, and the research was that files or cases or orders that are being made through like ADR that have more input from the families or the parties that are involved, there's more longevity to those orders than if they were imposed by a judge. So it's really important to curtail, like Margie said, and have your input into and fashion something that is satisfactory to you and specific to your family that has some longevity to it.
Yeah, great tip. All right, so last question. We're approaching 6 o'clock. What are the key factors considered by judges when making decisions in family court cases? We could do a quick rapid panel discussion. Courtney, what do you think?
Paramount is the children's best interests. I think we've beaten that dead horse tonight. It's basically about the kids. You know, you two are adults and you've made your decisions, and the judge needs to make sure that your kids are okay at the end of the day.
Yeah, agreed. Margie?
I think a lot of judges, apart from, you know, the best interest of a child, a lot of judges try to make common sense, equitable, like try to fashion common sense, equitable results, right? What you think might be fair is not what the law says. You don't think that your spouse of 20 years who never worked should not get a dime of spouse support. That's not the law.
Never heard that before.
But the judge is going to try to balance, you know, I think judges try to do that when you're talking about court. They try to balance and try to craft a very equitable result for everyone involved within the confines of the law.
Yeah, agreed. Michelle?
Yeah, like what we were talking about, you're not going to get away with just not complying with the rule. So, yeah, make sure you're disclosing your income, disclosing your assets. You can't, there's no way around it. The judge is going to make sure that you're complying with that.
There's a case Justice Quinn wrote saying court orders are not suggestions, right?
Yeah.
Gia?
Yeah, so judges are going to make sure that they follow the rules. So whatever order that they make, it's going to be within the confines, or should be within the confines of the legal test that may be applicable. And so just be mindful of that. Sometimes people are very emotional about things because it is their life, understandably so. But you're going to have a third party who is going to be looking at it from a different perspective and within certain parameters, making an order that's going to be affecting your life. So just be mindful of that.
Yeah, I guess the two things I think judges are considering, usually first time I meet the client, I'm always thinking, what is the judge going to be thinking on day 4 or day 5 of the trial, 2 years from now? And the question they're always going to be asking themselves, what parent is best able to facilitate the child's relationship with the other parent? And the way you conduct yourself throughout that 2 years will demonstrate, you know, I'm not going to give the kid up for Halloween because it's my night, or makeup time, or not consulting with the other parent, or encouraging the child's relationship with extended family. All these things come into play. So the judge wants children to have good relationship with both parents. And if you're not prepared to facilitate that or encourage that, that's seriously going to impact your case. The other issue I would say that underlines everything the court does is credibility. So when you swear your financial statement, when you swear an affidavit, we're seeing deep fakes now where people are making up text messages and other electronic evidence. That goes to your credibility. If you're not completely honest and candid with the court's going to reject all your evidence. They're not going to rely on any evidence that's inconsistent with yours. So although you may be thinking you're smart, hiding this cash, and it shows that you have cash, or, you know, creating this text message string that never existed, and the judge finds out, you're going to lose all credibility, and your case is going to go very badly, very quickly, with possible cost consequences. So you want to be mindful of that. Make sure that you're fair and candid with the court in your evidence that you present to it. And that's it. On that fun note, we're going to end tonight's presentation. I want to thank everybody, our audience, for joining us. We've had some fantastic questions tonight. It's always great getting these questions because we understand everybody's engaged in asking the right questions. Thank our panelists for donating their time after hours to share their wealth of information. You're going to see a brief survey that pops up. Please fill it out. It'll help us understand what topics we can explore and what we did well tonight. Again, email Nicole at Russell Alexander to follow up on that consultation. The access code is Darla 2024. She's one of the law clerks at our firm that we all love deeply. And she brought muffins in tonight too. So I wanted to give her a shout out. Thank you, Darla. And that's it. Thanks for joining us. Courtney, Margie, Gia, Michelle, have a great night. Have a good night, everybody.